Hello. It's only when I hit record. Hi, this is attorney Tasha Simmons, and I'm actually going to bed soon. I just wanted to quickly do this video. I had the idea. I've been trying to, think of some other videos that I can do, add to the channel, just to sort of help individuals who are representing themselves navigate their way through the family court system, and as well as thinking of ideas for other commentary and things like that. But meanwhile, I do want to maintain progress just with the pro se forms and helpful tips and things like that. Of course, nothing that I say in these videos on this channel are legal advice. I'm not your attorney. We would have to go through a bunch of steps for that. But what I'd like to do with this video quickly is just share my screen and explain very shortly what each of the free family law forms are for that you can find on the Florida Courts website, which is flcourts.org. It's bedtime soon. flcourts.org. Okay, so I'm just going to, without further ado, I'll probably hide myself here. Maybe I'll just be off to the side and we're going to get right into it. flcourts. All right. So we know we're in the right place because you have here Florida Courts. I'm on floridacourts.gov. You can get there with .org as well, so no worries, okay? And then you are going to click on self-help information, family law forms, and that's how I got here. Alrighty. So what I love about the Florida forms, right, is each one, when you download it, you can download, either the PDF or the Word. It has instructions that comes with it. That's why I'm not going to spend long on each form. I'm going to rip through these 4 pages of results just so you have a clear idea. Well, why do I want to click on this? What am I going to use this for? And then when you download it, you'll have the instructions to tell you how to actually use it. And of course, I will be, I eventually want to create a quick explainer video for each and every one of the forms, right? But for now, just in the name of getting something done, let's go ahead and just touch on what each of these forms are for. So these are the basic instructions here. Apply for civil indigent status. Let's start with that form, okay? And I'm not going to open each of these. I'm literally just going to run through the web page. Alrighty? But apply for civil indigent status. There's a court filing fee whenever you want to file a divorce. If you don't have a lawyer, then the only thing you're going to find yourself paying for is really what's called costs. So there's the clerk's filing fee for filing whatever the case is. It's usually somewhere between $405, $500 flat. If you fall within a certain percentage of the federal poverty guideline, then you don't have to pay that fee. Or you could qualify to get it broken up into $25 installments. So that's why you want to do that form and fill that in and turn that in when you file your paperwork. All right? Current address. Listen, when you start your case with all of the other forms that we're eventually going to go over, you won't need this until your address changes, because your information is going to be all over your paperwork anyway. All right, so do it. Sure, if you just want to do it to be complete, you can do it with your initial set of forms when you open your case, when you file your case, or when you first start interacting with your case. But definitely you want to use this form designation of current address and email address when your information changes to let them know. Okay, so now we're under, I'm going by the titles. I'm going to skip all the fancy statute numbers for the forms, okay? Motion for referral to general magistrate, order of referral to general magistrate, and notice of hearing before general magistrate. This is interesting that that this is available for the public to do for themselves, but I guess you can swing it. Really focus on the motion, because if you're self-represented, once you file the motion, the court will either do the other two on their own, or the case management office will reach out to you. And I'm speaking mainly from my experience in South Florida, Broward County, Palm Beach, Dade. Every county really is different, but every county does have a case management or something similar, that type of office, to assist judges with keeping the cases going forward, and to act as a liaison between the judges and the those who do not have a lawyer, because the judge's office and the judge's assistants, they're not going to talk to you. Okay, so just focus on the motion. Why would you want your case heard by a general magistrate? Most of the time it's because the judge is not able to get to your case until like maybe months and months out. You can get it quicker with the GM. I like referring things to the general magistrate as someone who's unrepresented, because you'll always have a court reporter there without having to pay upfront for court reporting. But you will, of course, have to pay for a transcript later if you need it. Notice of hearing, and this is for a child support case. Okay, again, the form is there, but once a hearing has been set, the court or the case management office usually is going to send out the notice of hearing. And a notice of hearing is just that mailing, that paper that you get that says, this is where you have to be in court, and this is why we're going to be there. So, you know, I just don't see where individuals who are representing themselves are being asked to do this on their own anymore. But if you are, that's what that's for. All right. Moving on. Instructions and motion for default and default. All right. So a default is when you get, if you are the petitioner, okay, you get the other side served. Once they're served, they have 20 days to answer. They didn't answer, so you can default them. Now, it takes 2 levels of default before you can close the case when someone doesn't answer. I see a lot of people representing themselves get their hopes up because they got this default. This is a clerk's default, okay? And just note the number. So you have a clerk's default, and then there's also a default called a judicial default. Okay, that's the one that's really going to end the case. But this one just lets the court know, hey, looks like the other side is not participating because they didn't file anything. All right. So you would fill that out, and you would leave. This one is 2 forms. Okay, it's the motion, and then it's the default itself. The default itself, the clerk is going to fill that out. You just got to file it, and the clerk will do it. They are going to look themselves, because sometimes someone will file an answer or a response, but it's not showing in the system yet. So you thought they didn't. So now the clerk has to look, and if they see something's been filed, even if it's not an answer or what they were supposed to file, the fact that they filed something, you can't get a clerk's default. You can get a judicial default, possibly, but if they filed any paper, then you can't get a clerk's default. A clerk's default means they filed nothing at all. Now, the next form, motion to set aside default or default judgment, that's if you've been defaulted against. And that's what that's for. I'm going to leave that alone, and you can read the instructions if you feel you need it. But if a default has been entered against you, but you still want to participate in your case, and you want the default put away so that you can participate, then that's the form you need. Notice of hearing general. Again, a notice of hearing means we have to be in front of the judge so the judge can make a decision on a motion or something pending before the court, and it lets you know what time you got to be there. You, as an unrepresented individual, you really will not be doing these, okay? So in the rare case that you will, the case management office will be telling you how to do that. Maybe if you're in a county small enough, the judicial assistant may communicate with individuals who are unrepresented, but by and large, the judicial assistants are not going to be doing that. It's going to be a case management office of some sort. Okay. A notice for trial means that the court can give you a trial date for your case. So I believe I've already done the video about the anatomy of a family case, how we have the opening up phase where everything's being started and initiated and you're getting served, and then the financial exchanges happen with the financial documents and all of that. And then you go to mediation, and if mediation doesn't yield an agreement, then you got to go to trial. So filing a notice for trial lets the court know we finished the opening part of the case. We finished the initial part of the case. Okay. So once the last answer is filed, and I'll just leave it there. If you're unrepresented, it can get a little more nuanced than that. But generally, once all the answers to the petitions and counter petitions, everything that opens the case up, once those things are filed, you can get a trial date. Okay. Now, usually, of course, not gonna want to give you a trial date if you haven't even been to mediation yet. But legally speaking, your case is trial ready once all the initial paperwork is done on both sides. And it also lets the court know this is how long I think we'll need for trial. Okay, so it has a line for that. I think it's going to be 1 hour, half a day, 2 days. But it just lets the court know, hey, we need a court date. And once it's filed, the court has to give you a trial date within 30 days. Whenever the trial date is, but they just have to give you one within 30 days. Notice of voluntary dismissal. If you file the case and you want to drop it, you just file this and it's dropped. That's it. Cover sheet for family cases. You'll see this covered in my File Your Own playlist, okay, on the channel here. It's a part of what I call phase one. You know, once you file a new case, the clerk will not give you a case number or open up the case without this being included. Some counties are moving away from this now because the e-filing portal will generate it for you, but I always stay on the safe side and just do one because it's so simple. Okay, but there's a video on how to do that. Now we get to these forms, okay? You see the word interrogatory, interrogatory, interrogatories, interrogatories. That's what they are. They're interrogatories. Okay, it's a fancy word for questions. Right? You remember how we learned that interrogative statements are question statements that end with a question mark? So basically, you get a certain number of these in any civil case. All right. Because you're pro se, I'm not going to bog you down with all of that. But these are the questions that anybody would want to ask in a family case. They've already put it together for you, which I like. It's a really good thing. All right. So what are each of these forms as it relates to that? This, you'll see the interrogatories. This is for, you know, when you're filing a case for the first time, opening a case. And then this one, okay, that's B for when a case is being opened for the first time. C is when you come back after the final judgment and reopen the case with a new petition. Okay. It's the same questions. Okay. So it's just worded differently, but it's the same questions you're asking the other side and they're asking you. So these are the actual questions themselves, B and C. Okay, A and D, I'm sorry, yeah, A is just a notice. This is what you file with the court to let the court know, hey, I sent the other side one of these. Okay, so this is the one that gets filed with the court. You don't have to file these with the court because it's just a blank set of questions, okay, that you're sending the other side to answer. So you just file this with the court to say, hey, we sent them this, and then you send them this, whether it be email, mail, or whatever. All right, and then when you answer, you know, you file your answer and you also file this. Notice is basically whenever you see notice, it's literally, we're letting you know. That's it. We're filing this to let you know something. Okay, we are putting you on notice. There you go. All right, so I want the court to know that I answered the questions within the 30 days. That's it. All right. See, here it is again. Notice of production from non-party. Why would you use this? I wish I could just spend a day on this because if more unrepresented people knew how to use this, I tell you. But basically, the subpoena for productions of documents from a non-party, okay? It's basically you're requesting documents that you need to prove something that you need to prove in your case, but you don't want it from the other party in your case. You want it from somewhere else. So let's say you're in the financial exchange part of your case. The financial documents have to be given over to each other, but they're not doing their financial affidavit and they're not giving over their pay stubs. And you don't want to bother learning how to do a motion to compel or hiring a lawyer to do it. Well, just subpoena their job for the pay stubs. Have their employer give it to you directly. Okay, so you have to do a notice first. You have to let the other side know, hey, I'm about to send the subpoena. You got to wait, okay, a certain amount of days to send the instructions. And then after, those days elapse, if there's no objection filed, then you go ahead and you do the subpoena. And the instructions are in there how to do that. All right. I just like it because it helps the case move along with getting what you need. Now, certificate of compliance with mandatory disclosure. If I could star, bold, underline, and italicize this and staple it to your forehead, I would. It's that important. Okay. After the case is initialized, after it's opened and all the initial filings and pleadings are in, right? You answered their petition, they answer your counter petition, and vice versa. You move into the next phase of the case, which is exchanging financial documents. This is that list of documents. It's both the list, okay, and you're actually going to sign and file this to let the court know that, hey, I complied. I'm certifying. This is another fancy word for I'm letting you know. But when you see certificate is I'm certifying, meaning I'm letting you know and I'm like swearing that I'm telling the truth. Okay, so it's pretty serious. Certificate of compliance with mandatory disclosure. You're letting them know, hey, I complied with the mandatory financial disclosure. Okay, very important form. All right. Now, these, just to let you know, if it's not obvious by now, the forms are not arranged in any logical. I mean, they're grouped together, but the groupings are, they bounce around as far as the subject matter. So you can skip around this video. I'll put timestamps in. You'll be fine. Alrighty. So here we go. Motion to modify or dissolve temporary injunction. Okay, this is not intended for use in domestic violence cases. Whenever you see DV like that, capital, that's domestic violence. Okay, it's not for that. Okay, there are different types of injunctions that you get, and this is in family court. Okay, a domestic violence case can be related to your family case, but domestic violence court is actually a separate court, which I know can get confusing because when you have a domestic violence situation, it can be both in domestic violence court and in criminal court. So it's a little funny that way, right? But this is different types of injunctions. Sometimes the court might say, look, you're not allowed to touch a bank account or spend any money, or you're not allowed to take the children here or there until the court decides this case. That's also a type of injunction. So if you find that the court put one in and you don't want it there, you want it to be dissolved, then this is what you would file. And then this order, again, the court would do their own, but you could send this to the judge after you do your hearing. Whatever decision the judge makes, they're going to put it in an order. Okay, so they have orders on here, but really, the order, it's not effective unless the judge signs it. You can send it in all day, but if the judge does not sign it, no one has to follow it. Okay, just be careful. I understand it's an order, it's on the Florida court website, but until the judge actually signs it, it's useless, no matter what you write on there. Okay, the next batch of forms relates to removal of the children. Okay, again, we were just talking about one of the types of injunctions you can get in family court. All right, so we have the motion here. So this is where you're going to ask the court, hey, can you order the other side not to take the children out of the state or not to move them or anything like that while the case is going on? This is the motion for that. Okay. If the court says yes, I'm going to grant your motion and I'm going to order the other side to stay put or keep the children put during the case until I decide what happens to the children, then this is the actual injunction that the court is going to sign. Okay? See, it's an order. Okay? So that's something the judge is going to. This is going to sign. This is also an injunction, okay, which orders the other side stay put or stay put with the children. Okay? The difference between them is one of them, the court does it just immediately without a hearing, which this is an exception to a big rule that a court can't just put in orders. They gotta, give each side a chance, issue a notice of hearing. You come to court, you guys get to talk, say your side. Let me not say get to talk, that's misleading. But you both get to quickly make your argument and the court makes a decision, right? And that's what after notice is. And this is how 95% of things are going to get done in court is after notice. Okay, that's why in my other video I make such a big deal, and you'll see on all of the forms at the end you have to certify that you sent a copy to the other side. Okay, so this is a tiny exception of when courts just run and do something without giving notice and an opportunity to be heard to the other side. All right, but they're the same thing. It's just maybe the court felt like it was an emergency based on what you put in your motion. Like you really explained in your motion, like, oh my gosh, this is why you need to put an order. They're on their way to the airport, or I got this cryptic text and I know I just found out they've been secretly preparing to leave the state or whatever. Okay. But if they don't feel like it's compelling like that, they're just going to set it for a hearing. And after notice, they'll make a decision. All right. So moving on. I see this used a lot by people who represent themselves because there's a lot of misunderstanding out there about how this works. And I realize I'm going to have to do a video on this that's probably going to be a little longer than the other videos I do on these forms. Okay, but emergency verified motion for child pickup order. Okay, now, was that a belch in the video? I'm so sorry. Well, if you didn't notice, you know now. So the emergency verified motion for child pickup order, right? Some people refer to the order, if it is granted, as a break order because it gives the police the right to go in and get the child. Usually when some people are having a dispute over custody, picking up the child or releasing the child or withholding the child, the police will tell you, look, we can't get involved. This is domestic. Well, this is the order that will allow them to get involved, the order to pick up. But you don't get an order without first filing a motion. Okay? So you're going to have to really read the instructions to understand what's an emergency, because what might count as an emergency to most people is not an emergency in court. Okay? But the important thing is you got to use these forms if you want the court to do that. Even attorneys have to use the state form for this. We can't use like our own little pretty documents that we have in our own office. All right. Guardian ad litem. What is that? There will be another video to explain all of that, but this is what you're going to file if you want the court to appoint a guardian ad litem to your case. Okay? And if the judge agrees with you that a guardian ad litem should be appointed to your case, then this is what they're going to sign. You see how it's motion, order, okay? All right. Motion to deviate from child support guidelines. Well, Tasha, what are child support guidelines? Child support guidelines is basically the formula, and I'm just starting with the explanation because we are going to get to that, and I wish this was grouped together with that. But the guidelines is what you're going to fill out so that you could actually calculate what your child support is going to be and which one of you are going to pay it. Okay. So, but if you do the form, the child support guidelines, and you think, this is a little low for the other side to be paying, or it's a little high for me to be paying, or you know what, we have our own agreement about our own thing. We don't want to do this number. Then you're going to file this motion to say, hey, I did the child support guideline worksheet, but can we actually set the child support number to something different? Okay, so there's instructions about how much you can ask to drop or raise it and what you have to put in there in order to convince the judge. Okay, so that's in there. That's the form that you're going to use. Testimony and attendance of minor children. I can't stress enough. We'd all like for children to come to court and testify about their in their parents' cases against one another. Okay, but unfortunately for the children, there are some situations where it might be appropriate or even necessary for them to come to court. And the older they are, the more inclined judges are to allow it. So this is the motion you are going to file. This one is the one that you're going to file. See, motion to ask the court, hey, listen, can you allow my child to come to court and talk to the judge? Okay, and if the court agrees that that should happen, this is the order that they're going to sign. Okay. Temporary support. Okay. As you might have heard in one of my other videos, the word temporary in court in general, including family court, means something a little different. Okay. And so does the word permanent. Temporary in any civil cases, particularly family case, means while the court case is going on, while the case is pending. Okay, so something can be temporary and go on for 3 years if your case is still going on for 3 years. You know, it's just before the final judgment happens. All right. So temporary support. You already know the different types of support. You got alimony, which is spousal support, and you got child support. So there are different things too that you might need done while the case is pending. For example, Your Honor, can you order the other side to please continue paying their half of the mortgage, even though they moved out because I'm about to be either evicted or we're going to get foreclosed on because he or she they're no longer paying their half, and I can't afford to pay it all. Which, I mean, you can ask for it as alimony as well, but either way, the form has all the options for that. Okay, so this is the one you're going to file A if children are involved. Okay, motion. And then if it's granted, then this is what the judge is going to, it is weird because it says motion over here, but see, it's temporary order of support. So that's a typo on their part. Okay, but that's what the judge is going to sign if they agree with you. And then this is the same motion, but it just takes out all of the parts you have to fill out about children if there's no children involved with your case. And then again, same typo, even though that says motion over there, this is an order. If the court grants it, then this is what they'll sign. Okay? Moving right along. Temporary custodial responsibility during deployment. These are some of the newest forms, okay? As you can see, 2020. All right. So all of these forms just refer to what happens with time sharing or custody when one of the parents is deployed in one of the arms of the military. Okay, so if you all have an agreement as to what will happen, you'll fill this out and you file that with the court. All right, if you all are not agreeing on what's happening and you need the court to make a decision, there's the motion. You just download it and fill it out and ask for what it is you want. Okay, if the court has a hearing and agrees that your motion should be granted, then this is what they're going to sign. All right. Now, after they have already signed it and made a decision, if one of you wants to change what the judge ordered here, then you would file this. Okay. Like, okay, I know what you ordered, but can you change it? All right. And then this is another type of agreement where the two of you say, well, look, I know what the judge ordered, but we don't need it anymore. We're good. You can come together and decide that the order you'll be relieved from that. All right. Okay. Relocation forms. Relocation is when the parent wants to move more than 50 miles from where the parent is currently living. Okay, and you want to move the children with you. But I mean, if you have joint, what's called joint custody, or basically you have a certain percentage of time sharing, then you're not. It's not like you're moving the children. It depends on where you're going, really. Because if you want to go out of state and keep them, 90% of the year, then yeah, you're moving the children, right? But basically, I know it says relocation with minor children, but it's based on the parent. Alrighty. So you can't do it unless you get permission from your co-parent or unless you get permission from the court. So if the two of you already agree about the relocation, then you just fill out the agreement and you file that. Okay? If you don't agree, you're going to file a motion. Say, well, Your Honor, can you allow me to go? I mean, honestly, I would file the motion anyway. And if you come to an agreement, then fine. You come to an agreement, you just file that after. All right. Now, it's like, what is a divorce petition doing here? This is a petition for dissolution of marriage, right? It's a divorce petition. It's a divorce filing. But this is the one you would file if you want to get divorced and also get permission to move with the kids. All right. Now, if you're already divorced, or if you were never married, but you already have a final judgment of paternity that, sets up the schedule and does all those other things, but now you want to come back after the case is done to ask for permission to relocate, then this is the one you would file. Okay. All right. Now, well, Attorney Simmons, I already saw a motion for relocation. Remember the word temporary, right? So before the court makes the final decision about the move, they can make a temporary decision to say, well, listen, based on what we know, based on what you've shown me so far, I think that, I think maybe I might allow you to move on a permanent basis, but I don't know yet. So I'm just going to let you take them for now until I make the permanent decision. Okay. If you want the court to do that, this is the motion you file. Okay. Once the court makes a ruling on that motion, this is what they're going to sign. And they can either let you do it, or you can see, deny it. The court's going to fill that out or tell you. Alrighty. Now, if somebody has run off with the children without getting your permission or the court's permission to make the move in excess of 50 miles, then this is what you're going to file. G is the motion to bring them back. Okay. But again, you can only file this if you already have custody rights. Yeah, separate video on that. All right. So the court is going to sign this once they make a decision about the motion. Okay. And again, that's just, the motion to bring them back. Final judgment. This is what the court is going to, one of these. Okay. You can see one of them is granting the relocation. The other one is denying the relocation. So the court's going to pick one of these to decide the relocation issue and close your case back again. If, this is a case where you reopened it in order to try to get the relocation. They're going to pick one of these. You're going to win or lose, and the case will be over. Disestablish paternity and or terminate child support obligation. Okay, you got a petition and you got an order. Okay, the petition opens a case. All right, motions are what you file once a case is open. You file it in the case, but there is no case without a petition. Okay, so petition to disestablish paternity. All right, so it's the opposite, obviously, of establishing legal paternity. I found out Junior wasn't mine, and I've been paying child support, and that should change. Really read this form, because it's a lot more complicated than, oh, I just found out the kid isn't mine. You really, all I'm gonna say to avoid spending too much time on this is, the minute you find out that might not be your kid, you need to file this. Okay, and also I think it's on here. File a motion for the uh, paternity test. Alrighty. So the court will hear the matter and then they'll fill this out when they make a decision. All right. Motion for contempt and enforcement. Now, this isn't one of those things where you'll get in trouble if you don't file it. This is just a good tool. It's a really good tool that people who represent themselves need to know about and use more often, like I said about the third party subpoena. Okay. A motion for civil contempt says, listen, the a court order says we're supposed to do ABC, and the other side, they're not doing it. So make them do it. Order them to do it, and if they don't do it, punish them. Okay, either make them pay my attorney fees, make them take a co-parenting class, make them do the, there are laws that lays out what you can ask the court to do. I won't burden you with that right now. And again, the form will probably have the boxes for you to check anyway. All right. I've never had to download this. I've always had my own motion for contempt, but here it is for you to download and for you to use. Okay. If a court order says something, not something you feel should be done, that's a different motion. But this is when a court order actually says you're supposed to do something, and the other side refuses to do it, and they don't have a justification, an adequate or legal one. All right. So again, this is a notice of hearing. You're not going to do that, at least in most places. You're not. If you have to, I feel for you. I'm sorry. Okay, but this this is to let you know, hey, we got the motion for contempt. This is when the court is going to have the hearing. You cannot just make up your own date. The court has to give you a date, which is the reason they do these. All right. Writ for child support. Writ of bodily attachment. I don't see where an unrepresented person would ever have to file this on their own, but hey, more power to you. Okay, so a writ of bodily attachment basically means arrest the person who's not paying child support. That's all it is. So usually you have to get the motion for contempt first. There's steps you got to take. So if you have to do this on your own, the judge will at least let you know when it's time to do it. But honestly, they're going to do that on their own. Especially if you have child support services and the Department of Revenue's child support office is doing the child support stuff for you, they're going to handle all of that. But if you got to do it on your own, there it is. That's the arrest him, arrest her order right there. All right. Now, this batch of forms refers to when you want to give legal custody of your children to someone who is not a parent, but not forever. You're not waiving or giving up your parental rights. You just either they're living with a relative or someone who's like a relative, and they need legal papers in order to get things done for them, like with school and medical and all of that. So that's what this batch of papers refers to. Okay, the 12.970. So, all right, so there are two types, and we're going to call this extended custody. I'm sorry, family. I'm just going to call it family custody. It's a longer title. You'll see that. But we're just going to call it family custody, which actually some family doesn't have to be related by blood. They updated the law during the pandemic. But there are two types, okay? So just read the instructions and it will let you know which type you need, okay? Waiver of service of process and consent. Just read it. Just read the instructions. Okay, you're going to read the instructions for both of them is what I suggest. And then whichever one you realize you're supposed to do, whether it's the one that's called temporary and the one that's called concurrent. Again, very confusing and misleading because both are both are temporary in the common sense of the word, and both can be concurrent in the common sense of the word. But hey, legal schmeagle, distinctions. All right, but when you realize which one you need, then go to the waiver for that one, and it'll explain to you what to do. And then, of course, whatever the judge decides, they're going to fill out one of these. Okay, if they're granting it, uh, if they're denying it, they'll write that. Okay, completely ignore this. I mean, it's great that they provided it to the public, but it's it's so highly technical and lawyery. I don't even know if it should be here, honestly. But I'll tell you what it is, because that's what I said I was going to do in this video. Okay, if there is a family law in place right now that you feel is unconstitutional based on your understanding of the law, and the case you're filing, part of your case is challenging that law, then you got to file this as well. That's as simple as I can put it, with despite the fact that that is not a simple issue at all. All right. Petition for grandparent visitation with the minor children. Okay, if you're a grandparent, there is a law that gives you very narrow, very narrow rights to ask for visitation time with your grandchild or grandchildren. Okay, and you'll see the form will give you'll see the list of things you have to check off or qualify for in order to ask for it. Okay, and if the court, after the court hears your case, they're gonna fill out and sign this, whether they're granting or denying it, and if they're granting it, how much. Okay, how you feeling? All right, we're I think we're like halfway through, so let's just keep sailing on to the end. All right, so we're now at the domestic violence bank of forms. Now, very important. I know that these forms are here on the Florida Supreme Court website, but if you are looking to file a case, I strongly suggest you Google your county's clerk of court. So you can just put in clerk of court and then your county's name in the search box and see what they have on their website, okay, for filing a domestic violence case. A lot of counties have county specific things, especially if children are involved. I think really you should start there. But here are the forms, okay? The forms and the orders. Okay, so you have the petition, and this is for domestic violence. Now, it's a little confusing because there's more than one type of domestic violence in Florida, and one of them is called domestic violence. I know. Okay, so we're going to see the different categories as we go on, and you'll see those are the other categories down here of domestic violence. But right now we're at domestic violence under domestic violence. Okay, so each type of form is going to tell you which one you need to fill out. Do you need to fill out a domestic, a repeat, a sexual, or a dating violence, or a stalking petition? Okay, so you'll look at the instructions and you'll figure out which one. If you read the instructions and it's like, okay, I need to file a domestic violence form, then here's the petition. Okay, again, very important that you go to your county clerk of court website because they have a lot of supporting forms that you're going to have to fill out. These are orders. The court will do these. You don't need to even pay attention to the orders. The court's going to do all these. Again, if you're in a weird county where they tell you to send it in, fine, send it in. Okay? But that's really it. Okay? Order setting the hearing, the court's going to do that to let you know where you got to be in court to prove the allegations or to prove what you're saying is happening. Okay? This is the order they're going to fill out if they decide you do not need an injunction. Basically, you lost the case. This is what they're going to fill out if they say, you know what, we're going to give it to you for now. We're going to give you an injunction for now until we can go to court and get all your evidence from you and your testimony to see what happened. And that's why the word temporary is there. Okay, so you have two of these. One is for cases that involves children. This is a stubborn little mouse tonight. What are you doing? What are you doing? And this one is for cases that do not involve children. mouse is being so stubborn. Okay. Now, same. This is the final judgment. If you do get it, final judgment means we went to trial. Okay. And look, you won. So here is the injunction. This is the one for cases involving children. This is the one for cases that do not involve children. And then this is an order of dismissal if you lost or if you didn't show up for the trial. Okay. Then they're going to dismiss it. Sometimes they'll reset it, give you a new date. But I mean, if the petitioner doesn't show up, usually they're going to throw it out without prejudice, meaning you could file it again if you need to, but don't wait long. All right. So this is the repeat violence form. You see, they didn't give you all that stuff because, they're going to do that themselves. All right. Supporting documents. They break up the repeat violence form. It's really weird. It's really weird. But, that's another type of domestic violence in Florida. The instruction will let you know if you apply for that. Okay. Supporting documents. Request for confidential filing of address. That's important. Okay. I would always do that if I file any type of these so that you have the permission. And this is important because co-parents, you have to give each other your addresses if you're going to have the kids. Once they're a legal parent, they are entitled to know where their child or where their children are laying their head at night. So if you don't feel safe doing that, then you need to fill out one of these requests for confidential filing of address. Okay. And that way the clerk will blot out your address on whatever you file, or, they won't spit it back to you if you don't put your address on there. Okay. So supplemental affidavit in support of your injunction. Basically, this is where you tell your story, but you don't really need this. I mean, you could add extra pages to your petition and you'll be all right, but you can do that. All right. Motion for extension of injunction. So this is after you won. Okay. The court might have given you the injunction, but it's only for 3 months or 6 months, and you think it should last longer because, hey, they're still doing it, or I'm scared, or what have you. Motion for modification of injunction is when you want to change something about it. Okay. So usually the person who got the injunction against them would file this, but you just open it and see if any of the instructions on there, any of the circumstances apply to you. Okay. Repeat violence. Okay. We're still on repeat violence. This is the temporary injunction, and this is the final. Okay. You already know what temporary and final / permanent mean. Okay. If the judge agrees with you that the injunction that you got, if you got it, it should be extended, then they're going to sign this order, which moves us on to a third type, which is dating violence. Okay. This is the petition for it. This is the temporary or interim injunction if the court feels that's warranted. And then after you go to trial, there's the final if you won. Okay. A fourth type, sexual violence. Same pattern. There's a petition, there's the temporary injunction, and there's the final judgment. There's so many different forms that's supposed to be filed with these that I'm not seeing here. And this is why I can't stress enough. Go to the county. Go to the self-help office. Okay. And then the final type, final is 1, 2, 3, 4. Fifth type is the stalking form. You can see how recently that was updated. I won't get into nerd hour here and explain all the reasons why, but stalking is not what most people think it is. I can tell you that. Okay, so make sure when you read the instructions, you're going by the definition of stalking on the form, not what you think it is normally in your mind, because the legal definition is different. Same pattern. Here's the temporary and the final or permanent one if the court believes you carried your case or you need it. All right. So what I know this isn't an instructions video for any particular form, but I mean, this is a very serious subject. Just make sure when you do your petition You're as specific as possible. Use dates and times. Okay. All right. Show cause for violations. When someone does something that the injunction says they're not supposed to do, like they get within a certain amount of feet of you, where they're getting too close, they called you or tried to contact you through a third party, whatever the injunction says they can't do, they did it anyway. Well, then now you're going to, um, this is basically letting the court know. They need to know, and they need to haul that person into court to explain what are you doing, and for the court to basically scare them into not doing it again. And there's the order on that. Okay. So now we move on to adoption related forms. Okay. So from the worst type of family case to the happiest type. Okay. Uncontested adoptions. A lot of step parent adoption and adoption forms here. All right. So let's get started. Okay. Consent and waiver by parent. Okay. So for step parent adoption, the natural parent would file this to say, hey, I'm with it. I agree that this should happen. This is the consent of the adoptee, who is the person being adopted. Okay. If you're the age of 12 and over, then you got to do this. All right. Affidavit of non-paternity. This is this is something that I'm so tempted to click on it. I'm so tempted to click on it. Just open it and see if you need it. I like to err on the side, like if I know who the natural parent is, whose consent would be needed, it's better to try to involve them in the case. And I know it's a bummer because, oh my gosh, what if they cause problems? Or just do it. Just do it, because some judges are going to be worried about due process to that person because they are entitled to notice and they're entitled to participate and be heard. Okay, because to grant an adoption, even a happy one like this, you're terminating the other parent's rights if they have any. And so this form is about whether or not the father, now, if there is a legal father, to even deny that too. All right. Affidavit of diligent search. This is, you can't find someone. Okay. Usually, it's usually the natural father, but that's not the only type of step parent adoption. I've seen the other way, but basically somebody is supposed to be on notice that this case is happening under the law, but we can't find that person. So this is what you're going to file to show the court, hey, this is all the stuff that we did to try to find them. We went to this website, we did that process, we searched here, we asked there, we ran a background there, here. So this is where you would just let the court know, I did everything I could to find that person, and we still can't find them. All right, the ICWA form, ICWA, the Indian Child Welfare Affidavit, really it's geared toward children of Native Americans, but they just never changed the title. Okay, you just got to file that if the child being adopted is Native American. Okay, particularly belonging to a tribe. You don't have to be living on a reservation, but I would, better safe than sorry. So Native American child, and just file it. It won't hurt. But it really is more applicable to those living on reservations. All right. Motion for search of the putative father registry. I can't get into that right now. I can't get into that. Okay. Just read it. There's no quick explanation. Okay, and then there's the order granting it if the court thinks that it should be searched. Okay, but basically the idea about that is they want to make sure if you can't find the guy, to give him notice that these proceedings are happening, that this is a good final last step to make sure everything was done that you could. All right, this is a joint petition. This is the actual petition, okay? But it says joint petition, meaning both both spouses, the spouse that wants to adopt and the spouse that is the natural parent, you're both filing this together. Okay, isn't that nice? This is the final judgment of adoption. Yay! Once the case is over. All right. And then this is the petition for adoption of an adult by a step parent. Okay. So you see, it's not a joint petition. That's why you're going to need the consent and waiver by the parent. Okay. All right. Petition for adoption information. This is after the case is over. Okay. If you need to get the information from the case, you need a petition in order to open the case back up to get that. And then if that petition is granted, there's the order releasing the adoption information. Alrighty. All right. Name change forms. Hey, name change. Please read the instructions. Some name changes, you got to get a background check. Some you don't have to do it. You know, some you got to have somebody on notice or certain people involved. Some you don't. Read the instructions. But this is straightforward. You want to change your legal name. Alrighty. The most important, the most like annoying part of this is that you got to give like a lot of your address history on the petition. But I mean, other than that, it's pretty straightforward. It's pretty straightforward, especially if you're going back to a name you've already had. Okay, so this is the petition you would fill out if the name changes for an adult. And this is the final judgment that gives you the name change. Okay, as a matter of fact, I think I need to update the one I have because I just did a name change for someone and I had to update that order. Yeah, no, I like the one I have. It works. All right, this is the petition you would use if the person whose name is being changed is a minor, someone under 18. Okay, but if they're over 12, they got to do the consent, just like with the step parent adoption. And then if the judge grants you the name change for the kid, that's the final judgment that the judge will fill out. And then this is, all y'all are changing your name. Okay, not just the kid, but mom might be finally taking her married name or leaving behind her old name and wants that to be reflected in her kids' last name as well, or just different reasons. Okay, but it's not just one of you, it's more than one of you. It's a family name change. That's what you would file to ask for it, and that's what you would file. That's what this is what the judge signs if it's granted. All right, so as long as you're not running from the law and creditors, your name change should be granted, which is the law. The court should lean on the side of changing your name if it's not evident that you're trying to avoid a debt or run from law enforcement. Alrighty. Here it is. Paternity. All right, the paternity forms. Okay, please don't be fooled. Just because these are the only forms that say paternity, it doesn't mean this is all you need to file. Okay, that's why you got to read the instructions. The instructions tell you, listen, along with filing me, you also need to go back on the website and file my friends along with me. You need a notice of related cases. You need a civil cover sheet. Okay, you need a summons. You need a notice of social security number. Okay, the instructions are going to tell you everything you do need to file. But this is the petition. This is what it gets it started. Your Honor, we're not married, but we have a kid. I want to be named the legal father, or I want him to be deemed the legal father so I can get child support, or I want to be deemed the legal father so I can, get custody, time sharing. And I see dads ask for the child support to be set by the court as well because maybe the parents can't agree on who's supposed to pay what or how the contribution for the child is supposed to happen. So, okay, just let the court decide it. We'll fill out the guideline worksheet. See how that comes out again? We're going to get there. So, for every petition, there's an answer. So, the respondent is going to file an answer. Okay? Or you could file an answer and a counter petition. Okay? I like to always file counter petitions unless the client is like, no, we don't have to do that. Because If that person drops their case, then the case is still going. And you don't have to start over from the beginning. Like, oh no, now I got to file my own case because I actually want the judge to do XYZ, right? If they decide I'm not petitioning for anything anymore, you still have your counter petition pending. So you can do just an answer or you can do both. And then if you file a counter petition, then that has to be answered by the other side. Okay? Alrighty. I am going to take a short break. Alrighty. Alrighty. I'm back. Let us continue. Is everything showing that needs to be showing? Yes, it is. All right. Click yawn. All right. So we left off at the answer to the counter petition. Here is that motion for scientific paternity testing that I mentioned earlier. Okay, don't only do that in a paternity case, do that also in the disestablishment of paternity case. Here's an order on the motion. Oh, a word about the disestablishment of paternity. I've clicked that link recently and it opened up, like, I think these are switched around. Like there's a mistake on the website. But it's like this one opens the disestablishment petition and the other one opens what's supposed to be this one. So just be careful when you look at the titles, when you download it, just make sure the form matches what you actually intended to download. Alrighty? And then this is an order on the motion. Okay, the court can grant or deny the motion for paternity testing. Why would they deny it? Too long for this video, honey. All right. All right. So final judgment of paternity when you finally get to the end of your case. I I hope for the sake of your mental well-being that that's not too long. But this is family court. You're gonna have to be strong. There's a lot that happens between that petition and that final judgment. Okay. All right. Next batch of forms. Order of referral to parenting coordinator. What's a parenting coordinator? Click on the form and find out. Okay. But this is what the judges. This is what the judge signs if they think one should be on your case. And this is for the parenting coordinator themselves to fill out. You don't have to worry about that. Report of an emergency, request for status conference. The parenting coordinator fills these out. I mean, you could do it too, but I mean, it's for them to communicate and interact with the court. All right, another recent addition of forms, okay, to the family law bank, collaborative law, something that was instituted recently, okay, just in the past few years. It's basically the peaceful route, okay, to divorce, where the only thing the court does for you is stamp the agreement you already have. Okay, so it's more than mediation. It's less than litigation. It's uh it's it's quite a bit to explain as far as how it's set up, but it's really cool. It's really cool, and you really should learn more about it. Um, but it's basically saying, hey, we're traveling a different path to our divorce here. We want to just do everything by agreement, even though we're not in agreement right now. We are going to work at an agreement till we get one. This isn't just some mediation where we're showing up because we were ordered to show up and, hey, we can come to an agreement or not. Like, we are going to settle this case before we even file the case. Like, we literally were just filing the case in order to have the judge stamp it and say we're divorced. The judge will not have to decide anything for us. That's the collaborative law process, okay? So they have introduction and explanatory remarks, which I'm sure are more thorough than what I just did, okay? And, these forms are really here to explain the process to you, okay? So this is, this one explains what your attorney actually does in this process for you. Okay, this is the agreement both sides are going to sign. Uh, well, together, these two. You have the principles and guidelines, and then the actual agreement. Both sides are going to sign that. Okay, and then joint notice, putting someone on notice. Okay, that's what we're going to file with the court. This is another agreement. Okay, confidentiality agreement. This is for the person that's going to assist you through the process, the person in the middle that manages the collaborative process. Okay, if you want to change or add something to the agreement, you'll fill this out, the amendment to collaborative law process participation agreement. All right. If it doesn't work out and you need to take it to court and find it out, then you're going to put the court on notice of filing this that, hey, we're not doing that anymore. Okay. The thing is, if you quit the collaborative process, you all got to get new lawyers. You can't use the same lawyers you used through the collaborative process. Okay. And then when you're done, again, you're only filing the case and you did come to an agreement and everything is nice and ironed out. This is your divorce filing right here, where you're just telling the court, hey, we did everything through collaborative. We just need you to stamp our divorce and let us go our merry way. Okay? All right, final judgments for dissolution. And by dissolution, they mean dissolution of marriage, aka divorce. So these are all the different orders the judge can sign to end the marriage. Okay, this is the one they'll sign if it was a simplified case. Okay, well, what's a simplified case? I'll tell you when we get to the petitions. Okay, all right, but this is the one we're going to file if the marriage had kids and we agreed on everything. So it wasn't collaborative. We were in court, but we agreed on everything. Well, Tasha, why is there uncontested and collaborative? I'll do a separate video. Okay. I see how that can look. All right. Uncontested with no kids. All right. Okay. Uncontested with property, with no property or kids. Okay. just a regular final judgment of dissolution of marriage with children, okay, and a final judgment of dissolution of marriage with children, with property but no children. So unless it says no property, it's going to have provisions for property in here. Okay, so just remember, there's divorces with children and property, there are divorces with children and no property, and there are divorces with property and no children. You're always, and they're simplified, which I just, even if you qualify for it, I think it's more of a hassle than just do an uncontested one with no children or property. Trust me. I'll do another video about why. Okay. Modification of final judgment. Okay. It's just what it sounds like. Final judgment was put in place, and the case is closed. You would have come back and change something about the final judgment. So you're going to supplement the judgment. So you're reopening the case basically. And so it's a supplemental case, right? So you have 3 different types here depending on what it is you want to change. Well, I want to change what's going on with the time sharing. That needs to change. Please read the instructions. You can't just get a change because you want one. You gotta qualify. You gotta meet certain criteria, okay, to change the time sharing. Hey, I want to fill out this one because I need to change the child support, or I need to change the alimony. Okay, listen. Don't file these after the date that the payments are supposed to stop. Okay, as soon as you discern you need a change, go to these forms, follow the instructions. You might read the instructions and realize, oh, I don't qualify. But at least you know. Don't wait. Okay. More final judgments. These are final judgments for petitions we haven't even seen yet. Okay? But these are final judgments for support unconnected with dissolution of marriage. Do not be confused. Okay? These are forms that are supposed to be filed by married people. When you see unconnected with dissolution of marriage, it doesn't mean, oh, this is for me because me and my co-parent have never been married before. No, that's a paternity case. Okay? This is for individuals who need to establish support or other things between them and their spouse, but for one reason or another, they can't file for the divorce yet. Okay? So I'm not even gonna. I'll touch on each form because that's what I said I'll do. But trust me, these don't get used often at all. It's a very special situation. All right, but this is if the support is granted in a case where there's kids. This is for if the support and a parenting plan is granted in a case with kids, and then no kids were involved in this case, but they're granting the other types of support that was asked for in the petition. But they're not divorcing the parties who are married. Okay. All right. Now you have your parenting plans. Okay. I'm really for filing these. Okay. You can either file them agreed because you and the other side filled it out together, you agree on everything, or you can just say, well, look, this is what I want. There's a box for that on there. This is what I want. And file that with the court, and hopefully the court will make that the parenting plan that governs you. Okay, but it has all the questions in there, all of the provisions in there to say who is supposed to do what and when, who has the decision making over this, when is the child or the children going to be with this parent and that parent. Just it tries to foresee whatever you can to avoid hiccups. All right, who picks up who pays for the phone, who can you travel out of the state, and how many days in advance you got to let me know, and all of that. Okay, so this is your plain vanilla one that, but if there are safety issues, okay, then you would fill out a parenting plan that has the extra provisions for keeping the children safe. I don't know what type of restriction you might want, but you can choose your from your options that you see in there. And then this is the parenting plan for when you're going to be long distance co-parenting, or if you're getting a relocation. Okay, so this is going to be the new parenting plan. Income deduction orders. Somebody has been ordered to pay support and it's going to come right out of their check. This is the paperwork to make all of that happen. Okay, so these are instructions which stand alone, which tell you something. Because an income withholding order or income deduction order, it really is a federal is guided by federal law, right? So, and that's why you see that phrase there. So you have the form you can fill out. This is the order itself. This is the income deduction order. They do the same thing. They do the same thing. Okay. Notice to payor. Okay, the payor is the person that's paying the support. Okay, we already know what a notice does. And then notice of filing return receipt. I can't tell you what that is. That's just open it and read it. I don't think I'm gonna read that. All right. Final disposition. You're not gonna need to do this. This is really something the clerk does. When a case is closed, this is basically the nail in the coffin. Okay, or the bow tied around it to say, okay, this is closed. This is what the case was about. Just a little statistics report so that they can file it away. Now, where are all of those petitions? I must have breezed past them. Petitions for the dissolution of marriage. Maybe I spoke about them and didn't remember. Because, yep, I didn't do any of these at the beginning. So let's go back to the beginning. Where did I start here? I must have started on page 2. Yes, I did. Which is fine. Let's go. Alrighty. So these forms relate to when you're working with a lawyer. This video is for pro ses. I'm not going to spend long on this. Okay. This form is if someone who's not a lawyer helped you with these forms, they got to fill this out. All right. If you have a lawyer who's going to represent you for only part of the case or for limited functions instead of being just your whole attorney for the whole case, they got to fill this out. You have to fill this one out saying, hey, I'm okay with the attorney doing that. And then when the attorney is done doing their limited function on your case, they have to file this to let the court know, hey, I'm out. Okay, I did that. I did the part. Now, if you're representing yourself and you're doing all these forms yourself, but you did have help by an attorney in doing it, but the attorney is not doing anything for you, limited or otherwise, you fill this one out. All right, and this is for the attorney to fill out if they are doing work on your case. This is the agreement you and the attorney are going to sign for the limited services on top of and in addition to the agreement you already have with the attorney. Okay, so this is like an addendum to your agreement with them. Okay, and it's there because the court was to the court was to ensure that you understand the limitations of your agreement. Notice of related cases. This is a phase 1 document, very important. If you're filing a new case, we're getting the case opened up. Likely will not be opened up without this. Okay, and again, phase 1 is something I made up, but you're not opening the case or getting anywhere without this. So now we have our divorce petitions, our divorce filings. Again, you have one for simplified, which I don't like, so I'm not going to explain it. You have one for cases involving property and children, but it's not going to say property. Just assume it covers property unless it says no property. Okay, so with children, you have one that says with property but no children, and then this one says no children or property. So those are the different, I mean, a divorce is a divorce, but those are the different types of petitions. And it just lets the court know what they're going to be doing in your case. Okay, so choose the right one. All right, supporting documents. The petition themselves, when you open it, they're going to tell you, hey, along with me, you also need to file this and this and that. So It's going to refer to some or all of these, but trust me, uh, not all of these are needed for the case to be opened up when you file it, but you will eventually end up filing some of them. So let me explain. Financial affidavit. Absolutely. Right? Your case will be opened without it, but you should get it in right away. Once the respondent is served, mandatory disclosure that that requirement that you all exchange financial information, that 45-day clock begins. This is the first thing you want to do. Okay, so there's a short one if you make less than $50,000 a year, and then there's this one for everyone else. This form, if your case involves children, you got to fill it out. I would just treat it like you're not going to get a case open without it. It differs from county to county. Just do it. It's vital. It's vital. Okay. It's called the UCCJEA. Okay. A lot of people refer to it by its initials, even though you don't see it here. The child support guideline worksheet, not required to file or open a case, right? But you're going to want to do it early because you need to know. Okay. You need to know. You don't want to wait until the hearing. Listen, I don't want to be negative, but once you open that form and look at it, no one sits there and does that math. Not even the judges. We use proprietary software that we purchase or lease from one of two companies who have created the software to figure out child support. Okay. If you think you're going to sit and do it with pen and paper, once you see how it's calculated, trust me, don't do that to yourself. Okay. I do child support calculations, like, even if you just want the child support calculation and we're not moving forward into representation, I kind of do those a la carte for people, because as you can see, the web form that they used to have here that did all the calculations for you, it's gone. And it was supposed to be back by now. I thought it was coming back, but it still hasn't come back. The web form for the financial affidavit is gone too. What a shame. All right. If you guys have an agreement on everything, then you're going to do your marital settlement agreement and file it with the court. Okay. Again, for the different types of cases you have here. But if you don't have an agreement, you don't have to file those. Affidavit of corroborating witness. You do this if you don't have a driver license or state issued ID. Okay, because you have to prove that at least one of you has been a resident of the state of Florida for at least 6 months. So somebody else fills this out on your behalf to say, hey, I swear that this person has been in Florida at least 6 months before they filed their petition. Notice a social security number, you got to do it in a divorce, period. I have skipped it where there's no children, and no one bat an eye. But best believe if your case involves children, you got to do that. Okay. And really, I do it in every case now. Just do it in every case. All right. So then there's a petition. Then there's the answer. Once the other side gets served, they file an answer. Okay. This answer, this is the one that says, look, I'm not participating in the case. Give them whatever they're asking for. You don't have to let me know about any hearings. I'm not coming to anything. I'm not doing anything. Just grant them the divorce and send me the paperwork in the mail. Okay? Very dangerous, but some people do it. And there you have it. You can also do this if you have an agreement to everything. It's not just a, hey, blow off type of form, but you can also use it if the other side just wants to sign the agreement and not participate anymore, and they don't want to go to the final hearing. Okay, read the instructions. This is your plain vanilla answer to just a regular divorce. This is an answer. So there's an answer for each type of petition. Okay. Now, like I said before, with the paternity case, you can file an answer and then also file your own petition. So it would be a counter petition, okay? If you get a counter petition back, you got to answer it. So here's the answer. Alrighty. And then they stuck this here, answer to supplemental petition, which I think is confusing for them to stick it here. But if someone, after the final judgment, no matter what kind of case it is, if someone, like, you get a petition for modification, you get a petition for relocation, any of the petitions we saw or we talked about, well, there you go. You're going to use this to file an answer to that. Okay? Unless there's an answer specifically for that with those forms. Okay. So this is what I was talking about. The petitions for support unconnected with dissolution. It is for married people, okay, who need to file for either child support, alimony, or both, but cannot file for a divorce or will not file for a divorce at this time for whatever reason. Okay. Supplemental modification petitions. Okay, when you see supplemental or modification, you know there's already been a final judgment. We're past that point, but I need to reopen the case to change something. All right, so there's a petition for each thing you want to change. You want to change the parenting stuff, okay? Or you want to change the money, the child support, or the alimony, spousal support. All right. Summons. Okay, this is also in my File Your Own playlist. I consider it a phase 1 document. Some counties will not open your case without it, which I think is ridiculous, but I think maybe I just got a bad clerk that one time. Okay. But you have to, if you don't have something else saying, hey, you don't have to serve me, then you got to do this. You got to get them served. You can't mail the case to them. You can't drop it off. You got to file the summons. And then after the clerk stamp it, you can't just file it and then take it to them. After the clerk stamps it, either the sheriff or a private server that you hire will formally serve them. Everything after that, you can just file, send them a copy, send them a copy. But when you first open the case, you got to have them served. Okay? Process servicemen, that's not for you. Okay? Subpoenas. Subpoena means give it over. Okay? So, subpoena for hearing or trial, you're telling them they got to come testify at trial or a hearing. Issued by clerk is the one you're going to use since you're representing yourself. They're going to stamp it. It has to be stamped by somebody verified. Okay, this is the one I would use because I'm verified by you by way of my bar card. But if you don't have a bar card, if you're not an attorney, then you're going to use the ones that say issued by clerk here. Okay, so subpoena for hearing or trial, you want somebody to come and testify. Subpoena ducis tecum for hearing or trial, meaning you want them to come testify and you want them to bring something. So if I were you, I would use this for the police. Okay, subpoena, I want you to come and testify, but ducis tecum, I want you also to bring the police report or the CAD report from the incident. Okay, and then subpoena for deposition. I would love to teach pro se individuals how to depose someone for themselves. I would love to see that. But Attorney Simmons, what's a deposition? Click on it and open it. But they're fun. They're fun. Okay. Military service. I don't see these filed anymore, but go ahead and file it, especially if you're self-represented, and let the court know what your status is because that affects other things in the case. All right. Notices and diligent search. This is a very nifty form. When you cannot find someone, there are, like I said before, you got to do diligent search if someone that's entitled to notice in a case can't be found. So there are the different types here, okay? And it is confusing. It is confusing. One is for anybody, one is for dads, okay? So you just open it and see which one you need, okay? This is, hey, we're putting you on notice that there's a divorce because I can't find you. Notice of action. This is when you try to do it by publication, meaning constructive service. I know I'm using a bunch of legalese, but basically, you can't find the person, and these are the things you have to file so that the court will proceed without them anyway. All right. So you have one for divorce. You have one for adoption, because again, for someone to be adopted, someone else's parental rights usually has to be terminated. So it's like, listen, we can't find you, so we're putting the notices out there, and I would suggest calling uh, Daily Business Review if you need to do this, okay? Because they know what to put in there, they know how long to run it for, and then you'll be able to do that, okay? If you're gonna not use an attorney, I suggest you give them a call. Alrighty, or one of their competitors. All right, there. Now the DMV record request is for you to find them. You fill that out, you send it to the DMV with the payment, and the DMV will send you their entire driver license record or whatever you request on there. There's different options: the tag record, the vehicle, the driver license history. Like basically, you can find that person. Okay, if the and whatever information Florida's DMV has. And finally, we have a certificate of service. Okay, whenever you send something to the court, you got to send the other side a copy. Okay, no side communication with the court, either side. You can't do that. Okay, you're not really going to use this form because the block that you fill out that says, hey, I sent it to the other side and this is their name and number and here's my information, that's already included on all the forms anyway. So it really doesn't need to stand alone like this. Okay, and we're done. That's what each form is for. So we are done. I hope you found this video helpful. It's long for a reason. If you're going through the website and you're like, what are all these forms? What do I need? Well, now you know. So have a good night and thanks for watching. Or have a good day. Have a good whatever time you're in. And thank you for watching.